Hello, students. This is the video lecture that I'm recording for Chapter 1 from the Ross textbook entitled The Rule of Law. Yeah. Here we go. Let's do this. What do we mean by the rule of law? Okay, what we do not mean is that the law is arbitrary and decided on a whim by one person. Here we have an image of comic book character Judge Dredd. In this science fiction dystopian universe where Judge Dredd exists, the world has kind of gone to hell, pardon my language, and judges function as police officers, but also judges, and they can carry out the death penalty instantly. So that's, Judge Dredd's famous tagline is, "I am the law." When he shows up, he could convict you of a crime and carry out the punishment immediately based upon, whatever the judge is feeling. Incidentally, the Judge Dredd movie with Sylvester Stallone, not very good. There's another movie just called simply Dredd. That one's very good. Thumbs up for Dredd. Anyway, the rule of law in best practices is not this. It is not one person. It is a system, a set of rules that are applied consistently and that people are aware of them beforehand. That's what we mean by the rule of law. It's something that's codified. It's something that everybody has agreed upon in advance, and that the rules are applied consistently. Now, laws do change. They do change over time, sometimes because we decide that the way the law was interpreted in the past no longer works in today's modern world. There's also things like technology. We'll talk about that in some upcoming lectures. There's always new technologies that come up which present new cases that weren't foreseen. Something like retweeting. Does the freedom of the press cover a retweet? Does the First Amendment cover a retweet? And then in the future, there will be new forms of communication technologies, and we will have to interpret those as well. Now, where do laws come from? The supreme law of the United States is the U.S. Constitution. Constitutional law establishes the nature and function and the limits of government. Sometimes U.S. courts can apply international law where it might be relevant. But in general, the Constitution is the supreme law of the land, and it does also protect people's liberties and gives a limit as to what government can and cannot do. The federal government has three branches, and if you remember back to your high school civics class, or maybe another class you took here in college, maybe you remember these three branches. We've got the executive branch, the United States president's at the top. These are the executives who oversee the government and administration. We've got the legislative branch. This is Congress, including senators, House of Representatives. There's also a legislative body at every state level. These are the people who actually write and vote and enact the laws. Okay, that's the way it's supposed to work, is that the legislative body actually creates and enacts the laws. And then the judicial branch interprets and oversees the laws and determines when they're being enforced correctly or maybe enforced incorrectly. And we also, this is the classic system of checks and balances, right? Where you have the three branches of government supposed to keep each other in check. And then we have the Bill of Rights. Now, the Constitution can be changed. The Constitution can be changed. We call these changes amendments. They are difficult to get approved. They are difficult to get approved. Most amendments that have been proposed have not actually been approved. And then we have 10. The first 10 amendments are known as the Bill of Rights. These were not in the original Constitution. And according to my understanding, I think what I remember from my history class is that, when the colonies, which, had just become states, approved the U.S. Constitution, there were people who said, we're only going to approve the U.S. Constitution if we also immediately agree to approve these Bill of Rights, including the First Amendment, Second Amendment, et cetera, et cetera, et cetera. So the deal was made that, these amendments are going to be approved very quickly. They weren't approved exactly when the Constitution was put into action, but it was, within several years later that we had the Bill of Rights. They had sort of been agreed upon. Anyway, that's where that's the foundation of the supreme foundation of law in the United States, the U.S. Constitution. Now we have laws about journalism and mass communication, which is the focus of this class. After all, they originate from 6 sources, but these are the 6 sources. I'm going to go over a couple of them, not all of them. I'm going to go over a couple of them. We have statutes. I've got some notes here, taken from the textbook. Statutory law is formally enacted by some type of legislative body. It could be at the city, county, state, or federal level, sometimes called black letter law. I guess this goes back to the older era when everything was printed in black letter. It means it's actually printed and you can actually look it up. It's written down somewhere. It's not just in a judge's head. These laws, statutory laws, are formally adopted through some type of public process that is clear and stable and made transparent so people know how the laws are being made. Examples of statutory laws, including all criminal laws, when it comes to journalism and mass communication, the laws about copyright, some of the laws about broadcasting, advertising, as well as access to government meetings and information. These are covered by statutory law. Now, this court case you should be familiar with. You may even remember it from some previous class, Marbury versus Madison, 1803. As I mentioned, the laws are flexible and even the Constitution is flexible. This was a landmark ruling in 1803 that firmly established that the judicial branch has the power to interpret laws. So Congress can make the law, right? But the courts can actually interpret them. And this is a matter of ongoing dispute, a matter of ongoing debate. Some people don't like it when judges interpret the law in a certain way because it could change the effect of that law or change the impact of it. But yes, this was a big court case, highly debated, 1803, Marbury versus Madison. Now, when the language of a statute is unclear or imprecise or somehow ambiguous, the courts determine how it's applied through something called statutory construction. And courts tend to engage in strict construction, which means they look at the literal meaning of the words and the clearly stated intent. Okay, what is the meaning of the words and what is the intent? Now we have what is called common law. These are laws made by judges based on custom, tradition, and prior court decisions. The rule of stare decisis means let the past decision stand, or something to that effect. I don't know the exact Latin meaning. Basically, if something has been decided and a precedent was established, then the later judges should abide by that precedent. They don't always have to abide. Sometimes, judges may say, hey, the way that was decided previously was not correct, but in general, that's the guiding principle. How was this similar case decided in the past? And judges do look to each other. They do look, how is this case decided over here? How is it decided over there? So there is sort of a consensual aspect of this where judges look around to say, how is this issue being decided? Now we have administrative law. In many cases, many areas, many parts of modern life, the government sets up some sort of administrative body to regulate that thing, such as what are the rules about elections and election financing? What are the rules about the stock market and raising funds and publicly trading stocks? What are the rules about running a radio or television station? That's governed by the FCC. So we have these different administrative bodies. It's a whole alphabet soup of initials. We have the FEC, FTC, FCC. There's others as well. They come up with rules and regulations that govern a particular area. The largest aspect of contemporary law is actually administrative law. These agencies are charged with enforcing these rules, and they have their own system of courts, right? Their own system of, people and venues to do hearings when there's disputes. Now, if there is some type of dispute that cannot be handled, let's talk about the FCC, Federal Communications Commission. If there is some type of dispute that the FCC cannot come to a clear resolution, then it can go into the other courts. But generally, it starts within that administrative body and the systems that they have set up. Now I'm going to talk briefly, all of this stuff is explained in more detail in the corresponding reading in the textbook, but I just want to go over a few points here. We have the structure of the judicial system. Jurisdiction refers to the court's authority to hear a case. And different courts have different jurisdictions. There are two types of jurisdiction. There is the general jurisdiction, and then there is a specific jurisdiction. Now, a plaintiff, meaning a person who's bringing a lawsuit or bringing a charge, can engage in something called forum shopping. This means you want to find, say, let's talk about district courts, for example. You want to find the district court that's going to be most receptive to your particular argument, okay? Because judges are human beings. They are supposed to be governed by what's written down, but judges are human beings. So maybe you feel, oh, I better bring this case in the 9th district. I'm more likely to win than if I bring it in the 10th district, for example. And the jurisdiction can refer to geographic area, but not exclusively. It means more than that. The issue of forum and proper jurisdiction becomes very confusing when we talk about a national newspaper. The New York Times is distributed, heck, it's distributed all over the world, but certainly it's distributed in every one of the 50 states. So if you felt that the New York Times had done something wrong, say defamed you, for example, what's the proper forum? What court has jurisdiction over that when the newspaper is everywhere? Similar things come up with online platforms as well. What is the proper jurisdiction? With newspapers, the proper jurisdiction is considered to be only one of two locations, either where the primary company is incorporated, where has that company been incorporated in terms of business regulations, or the main location of its business, okay? So determining the proper jurisdiction for a national newspaper can be confusing. Now, trial courts are the lowest level of the courts. This is where nearly all cases begin. Most court systems have 3 tiers. There's a state, a federal, and then some type of specialized court system. At the lowest level, again, trial courts are at the lowest level. Then there are 94 federal courts, which are also called district courts, okay? So if someone wants to appeal, I don't like the decision at the trial court, then it goes to the district court after that. Judges also feel that the routine press coverage of, there's so much press coverage of trials right now. Many judges feel that the routine press coverage of trial courts is actually a disservice, and it's creating a threat to the fairness of trials, because, it could cast some courts in a negative light, which is then, maybe one judge someplace did something wrong, then it casts all of them in a negative light, and it ultimately reduces the public trust in the judicial system. So the routine press coverage of trial courts is not something all judges are a fan of. Now we have the Supreme Court. This photo is certainly outdated, but this is what I found online, an image of the Supreme Court. It's 9 people. They are appointed by the President of the United States, approved by the Senate, but these are lifetime appointments. So the choice and the decision when a U.S. president puts someone on the U.S. Supreme Court, it's a big, it has a lot of impact, and it can have impact for decades because this is a lifetime appointment. The Supreme Court only has original jurisdiction in certain specific limited areas. They are primarily an appeals court. When something is at a district court and someone wants to appeal it, it can go all the way up to the Supreme Court. Or when a state Supreme Court has a decision that someone wants to appeal, again, it can go to the U.S. Supreme Court. Now, the U.S. Supreme Court does not have to hear every case that people want to appeal. They can just decide not to hear the case, in which case whatever was previously decided will stay and, will stand as the decision. But if the Supreme Court feels it is an issue worthy of their time or a pressing issue that needs to be resolved, they can decide to hear it. And incidentally, the number of nine judges on the Supreme Court is not set in stone, and theoretically it would be possible for the president to create more. If a president of one political party didn't feel like his political party was getting its way, he or she could decide, heck, we're going to add 6 more people. We're going to make it 15, not 9, and I'm going to put 6 people who are, likely to rule in my favor. So, that idea has been floated for a while. It's been floated at least since FDR back during the Great Depression, but I don't think that it's going to happen. I think Congress has more or less decided that, no, we're going to keep it at 9. An odd number, so you don't have a tie, right? If you had 8 people, you could have a 4-4 split on a decision. So if you have 9 people, worst case scenario, there's going to be 5 people feeling one way, 4 people feeling another way, and the consensus wins. Incidentally, the Supreme Court likes to issue decisions that are unanimous. I feel like that looks better to say, 9 of us all think this way. They don't like making decisions where it's 5-4, for example. And I know this is a lot of words. I try not to put too many words on any one slide. But first, if it's a criminal matter, the government can arrest someone for a crime if there's sufficient evidence. The case can be heard by a grand jury or a judge. Now, if you're indicted does not mean convicted. Okay, if someone is indicted of a crime, meaning there is probable cause to put you on trial, then it goes to a trial. And to be actually convicted and found guilty, there must be proof beyond a reasonable doubt. Okay, now, of course, all of these terms can be up for debate. What is reasonable? What is reasonable? But that is, the official standard. Beyond a reasonable doubt is required to establish guilt in a criminal trial. Now we have civil suits, okay? This involves 2 private individuals or organizations. Many communications issues are resolved through civil suits. The plaintiff is the person who's bringing the case. They are claiming some type of injury, claiming they were wronged. The accused party is known as the defendant. Civil suits typically end with some type of out-of-court settlement. Not always, but they often end with an out-of-court settlement. And the 2 parties sign something saying they're not going to discuss the specifics of the terms. But the reasons for out-of-court settlements are simply to bring it into the case, If you're, say, a very, very wealthy corporation, or you run a very, very wealthy corporation, and someone is alleging that you've done something wrong, rather than do this long drawn out process that might be in the courts for years and in the newspapers and in the news for years, and you feel like it's just going to tarnish your reputation, you might find it easier just to throw money at whoever's complaining so they go away. That doesn't necessarily have to be an admission of guilt. It may just mean take this money and go away. But we do have a lot of these cases that are handled in civil cases. And you should be aware of the term tort, not tart, tort. A tort is the wrongdoing or the damage that's done in a civil case. They call it a tort. Reading here from the textbook, the civil injury one person or organization inflicts on another is called a tort. So in a later lecture or 2, the term shows up, not a term that shows up in normal conversation, but that's what we mean by a tort. Okay, that's the end of my little video lecture on chapter 1.